We're gonna get started in just a couple of minutes. Just waiting for a few more people to arrive. I want to thank everybody for being here. I'm Doug Schneider, Democratic District Leader in the 44th Assembly District, and like I said, we'll begin in a couple of minutes. Just waiting for a few more people. We're gonna go ahead and get started now. Like I said, my name is Doug Schneider. I am the Democratic District Leader in the 44th Assembly District. I am joined today by Julio Pena, who's the District Leader in the 51st Assembly District, Shaquana Boykin, District Leader in the 57th Assembly District, Mariana Alexander, who is the President of the New Kings Democrats, and three plaintiffs in a new lawsuit that was filed against the Brooklyn Democratic Party today. That is Harriet Hines, County Committee Member from the 42nd Assembly District, Akel Williams from the 43rd Assembly District, and Nomi Rabea from the 45th Assembly District. I am going to...
Doug, this is Janice Henderson. I'm also a plaintiff with the 57th Assembly District.
Thank you, Janice. And there are some other of the plaintiffs as well. I'm not going to go through all of them. What I am going to do right now is I'm going to live stream on Facebook. So just give me 1 second. Okay, so that is preparing. So we will be live on Facebook momentarily, and we are limiting the question and answer to just the media. So the comments or questions in the Facebook feed won't be being reviewed during the press conference. So I want to thank everybody for coming. I want to thank the members of the press for coming. The reason we are here is that a lawsuit was filed earlier today against the Brooklyn Democratic Party about its egregious conduct at before and during the organizational meeting of the Brooklyn Democratic Party. This is the now third lawsuit that has been filed against the Brooklyn Democratic Party regarding its conduct relating to the organizational meeting. Several months ago, the the executive committee of the Brooklyn Democratic Party passed a emergency COVID amendment that attempted to outright cancel the organizational meeting. And that resulted in the first lawsuit that the conduct violated the election law. And the plaintiffs in that lawsuit won. And the court ordered the party to have a virtual organizational meeting. The next thing that happened was the executive committee at that point tried to nominate and approve vacancies for the county committee. And I'm gonna pause right here just to explain something, and that I think needs to be explained, which is that there are two ways for county committee members to become a member of the county committee. The first way is for you to petition onto the county committee. So that's the same as any elected official. You go out with your green petitions and you get signatures, and that's you have an election if you have an opponent. Otherwise, you just you automatically win. The second way is that if not enough people petition on the county committee, it creates a vacancy. I'm told that it doesn't appear to be streaming, so give me one sec. This is why I wanted somebody else to do this part. Okay, now we're live. So the other way to do it is if there's a vacancy, you can, at the organizational meeting, there will be nominations to fill those vacancies, and it is then approved by the entire county committee. So let me tell you what's really going on here. Normally, at the organizational meeting, there is a prescribed order of business. And the first order of business is to vote on the rules of the party. And the second, later point of business is to fill these vacancies. So here's what's really going on, is that because of COVID, there are less people that actually petitioned on to the ballot, onto the county committee, and more that needed to be appointed. So the party typically relies on the folks getting, petitioning onto the county committee, then giving their proxies, and then by virtue of that, they control the meeting. But because of COVID, far fewer people actually petitioned on, creating more vacancies, meaning that those votes that the party leadership, the party machine typically have to control a meeting did not exist this time. And so for the party leadership, it was vitally important for them to try to figure out a way to prevent the vote on the rules from occurring before the filling of vacancies. So the county committee meeting was to be held virtually on December 16th in a meeting that lasted just under 13 hours because of really inexcusable and unexplainable delays. And the key issue at that first meeting is that there was a set of rules that was being proposed by President of New Kings Democrats, who's with us, Mariana Alexander, and other members of the county committee. And we're gonna put those up real quick, I hope. Can somebody, oh wait, I think I need to share the screen, and then you can share your screen. I think it's Sage. Can somebody share the screen with the Alexander rules? All right. Does not appear to be happening, so let me do it. Oh, there we go. So if you look, anywhere you can expand that. Awesome. So if you look, these are the rules that were being proposed. And there was the first was to require Robert's Rules of Order at every meeting. The second was to limit the number of proxies that one individual can hold, so that one individual can't hold a huge number of proxies and control the meeting through that process. And Amendment 3 is the one that I think is really the driving force here, which would require that amendments to the party rules be approved by a majority vote of the county committee or unanimous vote of the executive committee. And we saw and see a lot, but especially in the last 3 or 4 months, the executive committee holding emergency meetings on just a few days' notice and fundamentally changing the rules of the party in order to control the meeting. So this rule would prevent the party from doing that, would prevent them from continuously changing the rules. The Fourth Amendment would be to strengthen the financial governance of the party. The fifth is to restore annual county committee meeting. And then the sixth is a repeal of a rule that had passed that automatically gave district leaders a proxy of anybody from their assembly district who didn't attend the meeting. So those are the Alexander rules that were to be voted on at the meeting. You can stop sharing the screen now. But before that occurred, before we got to that point, there was a motion to adopt the rules from the previous years. And there was a vote on that motion, and there was a very long delay before announcing the results. And then they ultimately came back, announced the results, that the motion had passed by 4 votes, and started to move forward. It was quickly pointed out that the number of votes cast exceeded the number of people legally allowed to vote. So that caused a even lengthier delay. And they kept coming back during that meeting saying, we're trying to figure out what happened. We're trying to figure out what happened. And then after hours upon hours, they came back and they said, they're still trying to figure out what happened, but there's clearly a problem. So they offered to rescind the vote, and recess the meeting and come back and do a revote next week, which was not acceptable to large portion of the people in attendance. So there was a motion made to recess the meeting. It went to a roll call vote. In the middle of it, they came back and they finally announced the actual results of the initial vote, that the motion to adopt the old party rules failed, and that it was clear that the motion to recess was also going to fail and the meeting needed to continue. It was at that point that we approached the party leadership. Mariana Alexander approached the party leadership and basically said, I think we all know that we need to adjourn. So let's see if we can figure out, terms that will allow us to do that. And ultimately, an agreement was reached on a procedure to recess the meeting. And if you have it, if you could share the omnibus motion, the bullet points, if you have it. The agreement, perfect. The agreement that was reached was that we would vote on the rules proposed by Mariana Alexander, and then recess the meeting on the following conditions: that the meeting would reconvene on December 23rd, and with a new notice sent out as required by law, that the order of business on December 23rd would be to elect officers, then fill vacancies, then consider additional proposed amendments to the newly passed rules. That other than that, no amendments to the rules could be considered, and that the current proxies would remain in effect through the December 23rd meeting. And this was explicit, and in fact, it was at the request of Carlos Sisora, who was chairing the meeting, that it be done in an omnibus vote. It was also their request that we do a voice vote and not a roll call vote, which will be important. I don't know if you saw yesterday's City and State interview with the chairperson Bishat. It directly contradicts some of the representations that she made during that interview. If do you want to quickly play the video of Marianne Alexander introducing the omnibus motion?
Apparently it's still not showing up on Facebook, but now I see in the upper right hand corner it says live on Facebook.
Yeah,
so
it said live on Facebook on my end. It should be on my political page.
okay.
Point of information, I don't see it on the, a couple of people are not seeing it on here.
I don't hear any audio.
Yeah, I think it doesn't look like that it's working, but I just looked, it's actually not on my political page, it's on my personal page. So it is streaming, it's just on my personal page. So basically, if you watch, the point of watching the Alexander video is just that it's very, very clear that the agreement was to recess the meeting and that it was recessing the meeting on specific terms. So the meeting passes overwhelmingly. In fact, Carlos Sisora calls it a landslide to adopt the omnibus motion, and the meeting goes into recess. Pursuant to the omnibus motion, the party then sends out a new notice of the second meeting, and it says, and you can again put it up, it explicitly says that that it is, if you look, it's the continuation of the meeting of the Kings County Democratic County Committee, which recessed on Wednesday, December 16th, 2020. And so that is again noting that the meeting was recessed. So the next day, December 22nd, they convened the executive committee of the Brooklyn Democratic Party because Carlos Sisora, who had chaired the first part of the meeting, had resigned. And so the executive committee convened to replace the chair and nominated former Assemblywoman Tremaine Wright to do that, to be the chair. Myself and some other people objected that you could not replace the chair in the middle of the meeting. And the party's position was we weren't in the middle of the meeting, despite that we clearly were in the middle of the meeting. So they purported to have Tremaine Wright as the chair. What really should have happened was that there is an order of secession provided in the rules that would have provided for, in Sisora's absence, for people to other people to have filled that role. Specifically, it would have ended up being District Leader Josh Scholar, who is one of the plaintiffs in the lawsuit. So then the second meeting starts on December 23rd, and it's I mean, it's a ridiculous disaster and a ridiculous anti-democratic meeting. The chair, Tremaine Wright, muted people in mid-sentence, myself included. I think I got less than a sentence out before she muted me. She had motions that she didn't allow people to speak on. There was no transparency over any of the votes taken. We didn't know who voted. We didn't know what proxies were held. And there was also, and this is really what's kind of, I think, probably the most important part of this, is that the party introduced a parliamentarian who purported to make a ruling that the omnibus motion that was agreed to by everybody involved at the December 16th meeting was quote unquote out of order and had to be rescinded. Now, that the parliamentarian doesn't have that authority to do that, but nonetheless, he purported to do that, vitiating the Alexander rules, and then proceeded to hold a new vote on nominations to fill vacancies, which was approved. And then they had a provision that there was an automatic proxy. So anybody who was just approved, who didn't attend the meeting, their proxies automatically went to their district leader. So that even though the rules say you have to give them an opportunity to opt out of that. And it was that procedural aspect. It was the filling of the vacancies out of turn and the automatic proxies that gave them the control that they needed to control the meeting, where they voted down the Alexander amendments and approved the party's amendments, the party's rules. So that is what was a little too long of a background. I am now going to turn it over to the attorney who's representing the plaintiffs in this lawsuit, Ali Naji.
Thank you, Doug. Thank you for that very strong recitation of the facts. There's a lot of facts actually here, and one of the interesting, challenging parts about this lawsuit was managing all the facts and laying out all the facts and laying out all the facts on how the leadership of the Kings County Democratic County Committee has gone out of its way to undermine a basic democratic process and undermine the rights of county committee members. Today, we filed a lawsuit related to what transpired in the county committee meeting. And one of the things, there are many things that went wrong that Doug described. And I just want to give you a bird's eye view, I think, of the legal issues that are going to be litigated here. The first is the omnibus motion that Marianne Alexander put forward, which was overwhelmingly passed. The reasoning given by the parliamentarian was absurd. As the lead attorney on the Stein case, I could not understand what his interpretation of the Stein matter was that said that omnibus motion violates the order. Certainly Judge Walker, who we will be appearing before again, will also seek to clarify his ruling through this litigation. The idea that county committee members cannot make motions from the floor is also wrong. I'd also like to note that the parliamentarian was very brazen in the words he used during the meeting when I recapped and watched the video, and basically dared us to sue him. I think his opening statement was, if you don't like it, there's a remedy, and it's called court. Well, here we go. We're back in court for the third time. One of the other things that we are seeking is the fact that the imposition of Tremaine Wright, former assembly member, I guess she's got one more day, she's still assembly member Tremaine Wright, as the chair was completely out of order and an abuse of power by the executive committee. The judge himself in both decisions, Ellington and Stein, has admonished the executive committee for acting beyond the scope of their authority and beyond and for undermining what is really supposed to be left to the county committee. The rules of the county committee are clear that there's a succession, and it actually only gives the executive committee power to appoint a chair when a meeting is pending. This meeting is certainly not pending. This is a meeting that is a session that was not completed. We started a meeting. Hundreds of people logged into the Zoom and were on the meeting. The order of business was not finished. The county committee members voted to recess the meeting or adjourn the meeting. Whether you call it a recess or adjourn actually is immaterial, but to continue it. In fact, the party boss, Rodney Bichette, was quoted in City and State yesterday saying, it was the middle of a pending meeting. I'm not sure what she means by that. I think what she means actually is that it was the middle of the meeting, and I agree with her. It was in the middle of the meeting. And because it was in the middle of the meeting, there's no authority for the executive committee to act. I would also add that if they're going to argue that Marianne Alexander's omnibus motion did not pass, then no rules were adopted. And if no rules were adopted, the executive committee does not have the power or authority to act. No matter which way you cut up this cake, Josh Scholar is the lawful chair of the county committee meeting because he was the third in line and the other two, upon information and belief, were unavailable. And because the wrong chairperson presided over this meeting, everything that happened in this meeting is null and void. Secondly, the idea that nominations for county committee vacancies could not be made from the floor is also a violation. Also a violation of custom of the Kings County Democratic County Committee because nominations were made from the floor in 2018. I believe Mr. Pena himself successfully made a nomination from the floor to fill vacancies. And there's no reason that couldn't have happened here. You can't change the rules and play procedural games in a way because you don't like the politics or what people are presenting. There is order here that has to be followed. There are rules that have to be followed. They cannot simply take these turns to undermine a vote that was overwhelmingly cast. And they don't have the authority to tell the county committee who the chair is. And frankly, we have also moved for contempt in court, which is a very serious motion, because what we're asking the court to find is that the leadership of the Kings County Democratic County Committee has acted in bad faith to circumvent and effectively undermine the court's orders. And we are seeking to hold them in contempt. One thing that could come with contempt is sanctions. And one of the sanctions we've sought out is to have an independent third party set up this meeting, set up the virtual platform, pick the vendors, and hand it over to the chair, and also possibly to serve as a neutral parliamentarian that advises the chair. I've never seen a meeting where a parliamentarian makes rulings. It's the chair that's supposed to make rulings. Perhaps Tremaine Wright is conceding she's unfit to be the chair and make rulings. Well, then she shouldn't even be the chair in the first place. So we're asking for all this again. As an attorney and a litigator and an election law attorney, I must say this is sort of a somber moment for me because there are much bigger things to be better things to be litigating. These are things that should never have gone this far, but this is a practice in Brooklyn that we do have to sue the party time and time again. And I want to thank my plaintiffs, my clients, and the New Kings Democrats for coming together in this moment to bring this lawsuit. And I did hear back from the court. We have a court date of January 7th. So stay tuned. Thank you.
And before we hear from some of our other presenters, since Mr. Najmi has to leave around 2:45, I do want to see if media guests have any questions that they want to ask, either myself based upon my presentation or Mr. Najmi. All right. Well, if you do, just you can just chime in, and we will make time for that. I'm going to now hand it over to Harriet Hines to talk. She is a county committee member, like I said, from the 42nd AD, and she's just going to talk about her involvement in the lawsuit. So Harriet, the floor is yours.
Yes, I'm involved in the lawsuit because I believe that suppressing people's voices denies them accessibility and inclusivity when participating in county committee, and therefore undermines the process of ensuring a fair and true democracy.
Thank you, Harriet, and hand it over to Akel Williams, county committee member in the 43rd. Akel, why is this so important to you? Why is it so important that you decided to be part of a lawsuit?
Hello, folks. Thank you, Doug. I think, again, my name is Akel Williams, and I think it's really important, and what made me become a plaintiff to this lawsuit is I believe that it is fundamental to our democracy to have transparency and confidence in our election integrity. And inherently, I would expect and want this level of confidence in the conducting of business within the Brooklyn Democratic Party. And for the aforementioned reasons, that's why I believed it was necessary to be a party to this lawsuit.
Thank you, Akel. And then finally, Nomi Rabaya, if you want to talk about why you're part of this lawsuit.
Because I think this is a danger precedent that because you don't like the way things are going, that you can automatically change it. That's very frightening to me, specifically locally, but in the national context. And I can't believe that when you're trying to say you want accessibility and fair democracy, that you're doing the opposite. And that's very scary. That's why I'm part of this.
Thank you, Nomi. And I think Nomi raises a good point, which is we need to see this in the context of what was going on in the national scene, where you had a presidential candidate lose an election and then spend 2 months, a month and a half, trying to reverse the result of a fairly held election. And what we saw at that second county committee meeting was the same thing, but more effective. They were more effective Donald Trumps. And it is so blatant what they did. They lost an election, and so they came back next week and said that election doesn't count. Therefore, we're throwing out the results of that election. And you cannot call yourself a small d Democratic Party when you are throwing out the results of a fairly voted on election. It is an embarrassment to the party. It is an embarrassment to democracy. We are the largest local Democratic Party in the country, and we are more Trump when it comes to process than Trump. I want to turn it over real quick. One of the issues that happened at the meeting was there was supposed to be a process where you could nominate vacancies to from the floor, and so there was a big issue, a big fight about nominations that were submitted by Shaquana Boykin, the district leader in the 57th Assembly District. Shaquana, why don't you fill us in real quick on what happened there?
Sure. Hello, everyone. Again, I'm district leader in Fort Greene, Crown Heights, Prospect Heights, and parts of Bed-Stuy and Clinton Hill. The issue with the vacancy filling was because we had a lawsuit, and when we had filled our vacancies, I did not put 5 CC members' signatures. So with us winning the lawsuit, the executive committee, I guess the chair never approached the district leaders who did not put 5 signatures on their nominations. So when they recessed the meeting, before the meeting, I had a lot of proxies because I joined, I decided to be a district leader because of county committee. So I was really excited because I've worked with county committee members and I had a lot of proxies for that meeting. And I feel like because of that, I was shut out of knowing the deadline. Like others, if you're not in the executive committee camp of saying yes to whatever the party boss says yes to, then you're not privy to actually what's going on in the executive committee. So when I approached the executive committee about this, I was told that the party chair needs to approve me personally. And of course, the party chair did not approve me. I'm not sure why. But at this meeting, when I tried to put forth the nominations to be filled, the motion, I believe the chair, Tremaine, said that we are not allowed to put up any motions to the floor. And then it was a rigged, I will say rigged, slates that we were able to vote on, which is not how it went the first time. The first time I submitted nominations, we were able to see everybody's nominations in any district before our meeting, so we can know if they're contested or not. But this particular meeting was a way to grab power, to get slates of people, district leaders who they have power with, to get new county committee members on that slate, automatically get their votes to the district leaders who were not there. So those district leaders and their proxies goes to the party chair, which makes it harder for us to vote because all the votes sits with the chair. So we can vote whatever way we want, but it doesn't matter if the chair has 3,000 votes. So that was my part.
Well, thank you, Shaquana. I want to just reference one other thing from the interview that the chairperson Bishat gave yesterday to City and State. In part of the interview, she references that usually that each amendment has to be voted on separately, and that the omnibus vote motion wasn't proper, and that no vote, she says, she says there was not really a vote, and that is directly contradicted by the actual meeting. The omnibus motion, again, was specifically requested by Carlos Cesura and the party leadership. And not only was there actually a vote, but as Mr. Cesura announced the results were overwhelming that the omnibus motion had passed. So that aspect, and there are others too that I won't get into, of that interview are just patently false. I want to again see if there are any questions from our members of the press. I see Bridget Bergen. I see Rebecca Lewis. Do either of you have any questions for us? So I am going to see if Mariana Alexander, do you want to add anything? President of New Kings Democrats, fill in anything that I missed or add some concluding words?
Yeah, I think I want to, I'll be brief, but want to make 2 points. One is on the kind of reform rules, or they've been referred to as the Alexander rules or the Mariana rules. And I just want to clarify that, hundreds of people had a role in writing those rules. It started in NKD policy committee like 2 years ago. We worked through a number of amendments and kind of figured out what were the most important ones that were practical and made sense and were actually incremental changes. There are some like revolutionary components, but on the whole, these are incremental changes to how the party functions. We then took those proposals and we, talked to every district leader that was willing to talk to us. We talked to every club that was willing to talk to us about these proposals and made substantive changes to their contents based on the feedback we got. So all of this is in the place of having a functioning rules committee on county committee itself. In the absence of that committee, I don't know if it exists. I don't think it does, but certainly its membership is not open to, all of us. This is the process that we went through. And so, yes, the rules were originally crafted within NKD, but they were ultimately arrived at through a more collaborative process than that. And then I want to kind of drill down on a point that Ali made, that this is a somber moment. And I think that that's really true, because there are so many other things we need to be focusing on right now. Evictions, the Georgia races, getting ready for ranked choice voting, all of these things should be what we are focusing on right now. But we have to hold the line on certain things. We have to have certain standards for our own democratic institutions if those democratic institutions are going to be successful. And one of those lines is that you can't break the law. So while it's unfortunate that we have to spend our time and money and effort on litigation, ultimately, I feel like the party has given us no choice by so brazenly breaking the law time and time again. So that's all I had to add. Thank you.
Thank you, Mariana. And I will conclude like this. We have spent 2 lawsuits, 26 hours over 2 different meetings to hold any semblance of a organizational meeting of the Brooklyn Democratic Party. And after all of this, okay, there's another lawsuit that I think raises very compelling points. I think anybody who watches that second meeting will walk away with the same impression that it was the most blatant anti-democratic meeting that you'll have, at the same time that we have the chair telling us how democratic she is, not letting anybody speak, and coming up with a scheme to overturn a legally taken vote. And so after all of this time, we very well may end up having to do it now a 3rd time. And this is, as Mariana just said, an absurd waste of time. It's an embarrassment to Brooklyn. It's an embarrassment to the Democratic Party. And my message is, listen, to the leadership of the party machine, it's not too late to change. It's not too late. You can still do the right thing. I'm not holding out, I'm not holding my breath, but I want to thank everybody for coming. I want to wish everybody a happy new year, and you should feel free to reach out to any of these folks about if you want to discuss further. So I'm going to ask Ali, do you have any parting words?
I just wanted to recognize people, other lawyers in the NKD family who were very helpful in getting this together. Joshua Kirshner, Matt Cuter, and Remy Green, who were very helpful in this process. And I also want to acknowledge the NKD Exco and all the volunteers in NKD who helped put together the exhibits and going through this 26 hours of video, especially my good friend Sage Rockerman and everybody else. Thank you.
All right. Well, thank you, everybody. Have a great rest of the day and have a very happy new year. And we'll wait till January 7th to get our first sense of what the result of the new lawsuit is going to be. So thank you, everyone.
All the best.
Thank you. Bye.
Bye.
Take care.